This was the suspension of charter rights. If the government decides to do this again, we need to set the precedent of how and why, or why they cannot ever do something like this again without producing the evidence.
But I wonder if you've had any feedback from Adam Skelly in terms of what's gone down these past 3 days.
I think he shares my sentiment that he's relieved that he's finally had his day in court after all these years.
David Menzies for Rebel News outside the Ontario Superior Court of Justice in downtown Toronto. And well, that's a wrap, folks. The 3-day constitutional challenge regarding the COVID-19 mandates has wrapped. The applicant was Adam Skelly, the owner of Adamson BBQ. And the respondents were the province of Ontario, the city of Toronto, the city's Board of Health, and Dr. Eileen Davila, who was the medical officer of health at the time. And when I say at the time, we go back to November 2021, when Mr. Skelly said, that's it with the lockdowns. He complied with 2 weeks to flatten the curve. He complied with the further lockdowns during the so-called second wave. But by this point, he needed to make a living, and his staff needed jobs, and his customers wanted the best barbecue in town. So he opened his barbecue, and well, it was the authorities, they were not amused. Mr. Skelly was fined. He was trespassed on his own property, if you can believe it. He was incarcerated for over 30 hours. He was put into bankruptcy, and get this, he still owes the city $187,000 for what? Oh, for the cost of policing, including the mounted unit, which was unnecessarily sent in on day 3 of the rebellion.
Where's he going? Shame on you!
Now, there were incredible arguments made these past 3 days, and I suggest you check my previous coverage to get the nitty-gritty. But right now, court has been adjourned. The judge, Janet Leiper, is going to take, I would imagine, several weeks before she produces her decision, and I can't wait for that. But in the meantime, I'm going to speak to Skelly's supporters, many of whom packed the court today. As well, Ian Perry, his lawyer, has conceded to come on camera for a brief interview. Here, let's go check it out. Well, folks, I'm with Ian Perry. Mr. Perry is Adam Skelly's lawyer. And I got to say, that was quite an odyssey over these last 3 days. Can I get your assessment, Mr. Perry, on how things went in terms of your arguments, and what did you think of the Crown's arguments?
Well, I thought everybody made fulsome submissions, certainly. I was very pleased that the court was very patient with everyone's submissions, allowed everybody to get their points out. I think the Crown made, again, a fair response, a full response to the arguments that we made, and I'm really happy that we heard the judge confirm in the final moments there that she was going to decide this on the merits, and that this thing will get the full consideration that I've always said it deserves.
What I make of all the proceedings is that everything that could have possibly been brought up was brought up, with the exception of just the charter issues. There was Section 12 and 15, and also Section 36, which is about equalization. Those things were not, but everything else was fully tackled at the arguments, especially with respect to the evidence. And the evidence is before the court, and everything regarding the province and the city were fully addressed.
We've had 3 long days, but the biggest thing that came out of this was the lack of evidence that the government, Eileen Davila, City of Toronto, Toronto Public Health had in order to call the suspension of our protected charter rights.
Well, I was there when it went down, as you'll remember. That was the first time I actually encountered you. I had never knew who you were. I saw you at the Adamson's barbecue. The horses came in, and at that point, we just wanted to go out for a bite to eat. We wanted to have restaurants open. We knew that it seemed that it just wasn't right. So, from there, we followed the story all the way through, and this is the culmination of it many years later. And there are many faces that I see that I've seen for years and years. So these things don't go away. And the ones that stand up and do something about it and continue to show up, they're the ones that I'm with, and I think we all need to come together and unite together as a group of people who care about our country, care about the injustices that happen, and do what we can do to solve them. So.
Now, the X factor, as always, is what the judge is thinking, how the judge is going to rule. We'll find that out in a matter of weeks. But if she does rule in favor of Mr. Skelly, what does this mean in terms of so many other cases out there, so many other people that were fined and arrested and so on during the dark days of COVID?
Well, it depends on how much she gives weight to public interest standing. She has to grant it first, and then how much weight does she give public interest standing? Because public interest standing is essentially Adam's ability to step into the footsteps of the public, right? To represent them in terms of the merits of this case. So if it's more about private interest standing and the personal circumstances regarding this case, that's of less importance. It could be important in terms of just, charter rights themselves, but it would be very specific to him. That's why public interest standing is critical, and that's why my organization, the Concerned Constituents of Canada, which I'm co-founder director, federally incorporated not-for-profit, and I'm not a lawyer, I'm just play one on TV, but that's where we come from, that this is a public interest challenge, and it requires public interest standing so that everyone's rights can be considered, not just the rights of the applicant, Adam Skelly.
The city, the Crown, Eileen de Villa offered zero evidence as to how they came to the decisions to suspend our charter rights. And under Section 1 of our charter, there is a thing called the Oakes test that has been upheld by the Supreme Court of Canada. It's a test about rationality, a test about balance, and a test about proportionality before you can suspend people's rights. There's a process. They have to provide evidence and the experts who brought forward the evidence to suspend the rights. It was acknowledged by both the Crown and the city and Eileen de Villa through testimony or lack thereof that they had zero evidence to base any decisions. And what was really pertinent to here was Dr. Hodges' testimony. He was the expert that was called by the Crown, by the province of Ontario. He was their expert witness, public health witness, who himself said, I was not allowed access to the evidence.
Yep.
I was not allowed access to the people who made the decisions. I was not allowed to sit at the table.
Follow the money, buddy. Follow the money. Yep. The big boys can do whatever they want. Province can do whatever they want. The government can do whatever they want. You know why? Because they got the money, they got the power, they hold all the chips. And unless we stand up and do something against it, it was amazing to me. At the Adamson's barbecue, you had all the big television stations standing at a distance, watching what's going on. They reported very, very selectively. And if they would have turned their cameras, as you say, just 45 degrees that way, they would have seen hordes of people getting in there, eating their food, coming out, yeehaw. And yet, he's still going through the ringer 6 years later. So it's pretty clear, man. You follow the money, you follow the power, you figure out what's going on.
I thought one of the jaw-dropping pieces of testimony yesterday, Mr. Perry, when you were talking about Dr. Matthew Hodge, who was the province's medical health expert, admitting when he was crossed that he never had access to the data, he never had access to the people making the decisions, and said words to the effect of, I'm just a minnow, the sharks do as they wish. What did you make of that?
Well, I don't want to comment too much on what was before the court, but certainly those excerpts of the transcripts were read. And in our submissions, it goes to the Section 1 analysis of whether these infringements were justified. And we pointed the judge to those submissions to call that, that very point into question.
We have never seen in the history of Ontario, and probably Canada, a bill for $187,000 to close down a restaurant that typically has 30 to 40 people occupancy.
And Jim, I did a Google News search and I could only find one story about this case from 2 days ago in the Toronto Star, and of course the reporter went out and sought a legal expert to throw water on the arguments put forth by Adam Skelly's lawyer. But I'm very surprised because since you were at that 3-day rebellion, you saw every media outlet was across the street. Why all of a sudden, well, I mean, it's almost 6 years later, but why are they not interested in what could be a very important constitutional challenge should Mr. Skelly prevail?
Oh, you mean you're talking about the news agencies there who are the right arm of the government that gets paid by the government to report on it so that everybody else forms a public opinion as to what's going on? You're talking about those guys? Why they're not here? Well, I'll tell you, it doesn't really matter because you're here. And the independent reporters are here, the ones with the cameras, who's going to take it to the people, who are going to give it unfiltered, uncensored, the truth. You see, the thing is, people are afraid of the truth. You know why? Because it might show them up for who they are. And I'll tell you something, Rebel News, the independent reporters, and the good people of this, I want to talk about that cop actually for a second. I'd love to, but maybe I won't. Those are the people that matter. MSM is a propaganda arm of the government. They're being paid by the government. They're trying to brainwash the masses. So that's why.
But the other thing that they talked about was Ma brought Ma, who was representing the city.
That's Penelope Ma, the Toronto's lawyer.
Correct. She was representing the city, and she said that they didn't have to bring in evidence for why they made this decision because Eileen de Villa was a medical officer. So whatever she said goes. They didn't have to provide evidence. They didn't have to provide correspondence as to how they got to those irrational decisions. And in one spot, she said Eileen de Villa had the authority to make these decisions. And then in another, she said Eileen de Villa was actually given legal advice that she did not have the authority to make these decisions.
Did you pick up on any cues suggesting on how she might rule on this case in the weeks ahead?
It's really, really tough to say. And I think, one thing about Her Honor was that she's very, very diplomatic and heard everybody's points and was very careful in her consideration. So it's really anyone's I don't want to say guess, but it's tough to say where she's going to come down on this. But again, most importantly, our submissions were heard. They were heard on the merits, and we're certain that a just outcome is going to arise from this.
Which again goes to the overreach of power of Eileen de Villa. She did not have a rational reason to lock Adam's doors and claim occupancy of that restaurant. And we heard a lot today about occupancy. Who is an occupant defined under the Trespassers Act and under HPPA? And because her authority is under the HPPA, we have to go with that definition. And under that act, she did not have the authority, nor is she considered under that definition an occupier of the premises. And she's trying to say that Adam was not an occupier of the premises because one, he wasn't at the premises when it got locked up, because apparently all restaurant owners are supposed to sleep at their restaurant, and two, because she didn't know when the locks got put on. So, the police acted of their own accord, even though they were hired as agents for Toronto Public Health. So were they agents of Toronto Public Health, which now makes you responsible for all the actions they take, or were they rogue people doing their own thing?
Can I ask you too, Mr. Ryan, the lawyer for the province, he did a hypothetical comparison. He said what Adam Skelly was doing, it's kind of like if you were against speed limits and to exercise your freedom of expression, you would decide to speed recklessly, and therefore that wouldn't hold up in court. The reason I was speeding, Your Honor, was because I was simply protesting speed limits that I don't believe in. But was that a valid comparison?
Well, I think I see his point, and I think in my submissions in response to that, there are limits to protected expression, and the Supreme Court has said things that would, encourage violence or cause violence, and that's sort of the analogy that I drew. Things that might be violent in nature wouldn't be protected expression. So I don't see speeding as something that it certainly could be expressive, but I don't think it would be protected expression.
I think you mentioned it's inherently a violent act.
Right. Yeah. That's right.
And it's so perverse, Jody. The GTA is undergoing the greatest crime wave in its history, but it was calling all cars, send in the mounted unit to shut down a barbecue restaurant. I mean, little wonder this story, became the laughingstock the world over. One last question, and it's the big question. The X factor when it comes to a court case is always, always, always the judge. We can't read minds. If you were a gambling woman, how do you think this is going to go?
I believe it's going to go in our favor. Judge Lepure, she spent over 26 years, I believe it was, in the Ethics and Integrity Commission. The woman asked pertinent questions. She asked for clarification where it seemed very confusing. But not only that, she took to task all the lawyers with what they were trying to define, what was the authorities, and what made sense and what didn't make sense. She really seemed to understand the case, and she did an incredible thing. She said, a lot has come to light since March 2020. I need to take my time. I will not be rendering a decision today because I need to get it right. She understands the importance of this case, not just for Adam Skelly, but for all Canadians, all Ontarians. This was the suspension of charter rights. If the government decides to do this again, we need to set the precedent of how and why, or why they cannot ever do something like this again without producing the evidence.
But I wonder if you've had any feedback from Adam Skelly in terms of what's gone down these past 3 days.
I think he shares my sentiment that he's relieved that he's finally had his day in court after all these years. I haven't yet spoken to him today, and I know that he's, I think, overall just most satisfied and most pleased with the fact that he's finally been heard on this challenge. Yeah.
Thanks for your time, sir.
Thank you very much.
Hey folks, I know you love it when Rebel News brings you the other side of the story, and for such an important constitutional challenge, it's amazing the mainstream media are AWOL. They are simply not interested in covering this story. I wonder why that is. In any event, please go to bbqtrial.com. That's bbqtrial.com. You can see all our coverage of the Adam Skelly matter, and if you're able to, can you kindly make a donation so that Rebel News can continue to bring you the other side of the story?